Hi and welcome back to another video on A-level law. Today we're going to be talking about the two defences of insanity and automatism. Quite often these can be referred to as insane automatism and non-insane automatism, so just watch out for that. Insanity is obviously insane automatism and automatism is non-insane automatism, but for the meantime in this video we're going to call them insanity and automatism. Right, we're going to start with insanity. This is a defence which results in what's called a special verdict, and the special verdict you would get is not guilty by reason of insanity. So what that means is you're not just found not guilty, you're actually found not guilty by reason of insanity, and there's special outcome of that which I'll go through in a minute. Insanity is defined in common law, so it's defined in the case of Macnaghten, and in Macnaghten the defendant shot the Prime Minister's secretary, trying to kill the Prime Minister obviously. And actually the law was actually defined after the case extrajudicially. So they sort of decided the case and allowed them to use insanity and then sort of said what the law was afterwards. That's called extrajudicial, after the case. And they set out the law as D must be suffering from a defect of reason resulting from a disease of the mind, which meant that the defendant did not understand the nature of the quality of the act or that it was wrong. And obviously you need medical evidence from at least 2 doctors to demonstrate that, particularly the defect of reason from a disease of the mind part, and that you didn't, well, all of it really, and the fact you didn't understand the nature of the quality of the act or that it was wrong. So you're going to need psychiatric evidence generally for that. So that's the test. We can break it down to 3 key parts: defect of reason, disease of the mind, and the defendant did not understand the nature or quality of the act or that it was wrong. So we're going to look through each part of that now. So we're going to start with defect of reason. Once I've covered special verdict. So special verdict, as I said, is not guilty by reason of insanity, and I said there's special outcome for that. You're not just acquitted and sent home. Now, before 1991, it was compulsory detention in a mental hospital, which obviously put a lot of people off pleading this, because it also meant that there was no set time limit you'd be in there for, whereas if you got a prison sentence, for instance, you'd be out in a certain amount of time. So it put people off claiming insanity. Since the Domestic Violence Crime and Victims Act 2004, this has actually extended the sentencing options now. That's actually overruled the Criminal Procedure Insanity and Fitness to Plead Act, which you can see there in 1991. So the law now is the 2004, and it set out 4 new sentencing options really. Number 1 is an absolute discharge, so you can be completely free to go. Number 2 is supervision order. Number 3, a hospital order where you have to go to the mental hospital. And 4 is for murder only. It is indefinite hospital order, and you have to have the Home Secretary's permission for release, and that's obviously in very extreme cases. Now, starting with defective reason, as I said, the main case on this is Clark. Clark went to a shop and stole some tins of Spam, I believe. And afterwards she said, "Oh, I just didn't realise I was absent-minded," and she tried to claim insanity, and they said, "No, absent-mindedness is not a defect of reason. Just forgetting to reason, forgetting to think about it, being absent-minded is not enough. It has to be the inability to reason. You're actually unable to reason, not that you just didn't." So that's really important in that case. That obviously the defect of reason has to come from a disease of the mind, and this is really the big bit of insanity. Bear in mind it's a legal, not a medical concept. A disease of the mind, people would think of mental health, so they think of things like schizophrenia, psychopathy, things like that. It's not actually that sort of definition. Obviously those things would be included, but it actually is talking about internal causes. Disease of the mind means something that's caused by an internal cause. So there's a number of cases on this. The first one is Kemp, and in Kemp he hit his wife with a hammer, and killed her, and he was suffering from what's called arteriosclerosis, which is a hardening of the arteries which restricted the blood flow to his brain. Now, we wouldn't normally class this as a disease of the mind. People would think, well, it's not a mental health problem, but it did affect the mind and it was an internal cause, so therefore the court said that he had to rely on insanity. He couldn't use automatism, for instance. He had to rely on insanity, which obviously isn't particularly popular because of the outcome of that. And bear in mind that was before 1991 as well, I believe. So he would have been going to a mental hospital for that. Sullivan basically kicked a man, and he was epileptic. And again, the court said epilepsy is an internal cause, therefore it's a disease of the mind. So therefore, they has to rely on insanity. So again, epilepsy we wouldn't normally treat as a disease of the mind now. It is actually specifically a disease of the mind, but it's not what we would mean under the context of the laws trying to stop here around insanity really. It's a physical condition rather than a mental health problem. Hennessy, he stole a car, and then in police custody he felt unwell and then said he didn't remember taking the car in the first place. And he was actually diabetic, and he was suffering from hyperglycemia, where he had too much, if I get this right, too much sugar in his blood, and his condition was causing that, and there wasn't enough insulin to stop it. He hadn't injected himself with insulin, it was his body internally doing it. So they said, well, because it's internal, again, it's insanity. Now, contrast that with Quick, where a nurse attacked a patient. In this one, he had taken insulin but failed to eat, I believe. And that was because he injected insulin. That's an external cause that was doing something rather than just his body doing it. So therefore he could rely on automatism. We'll talk about the fairness of both of those cases and the fact that they contrast on very minor points there shortly. Burgess smashed a bottle over a woman's head while she was sleeping and hit her with a video recorder, and then had no recollection of this and claiming she was sleepwalking. In the UK, or in England and Wales at least, the courts treat that as insanity, so sleepwalking conditions as insanity, and that's significantly different in other countries. So we'll look at that when we come to the essay on this. So disease of the mind, as you can see, it's not just about mental health problems, it includes physical conditions as well, as long as they're caused by an internal cause, and that's really the key phrase there, internal cause. All of that must mean that the defendant didn't know the nature and quality of the act, or that it was wrong. Now, an extreme level of functional impairment is required here, so you need to really not know. You have to be able to prove that you absolutely didn't know the nature and quality, or that it was wrong, and that will come from evidence from doctors, usually psychiatrists. It does exclude irresistible impulse or uncontrollable desire, even if emanating from mental illness. So psychopaths actually can't generally use this, as you saw in Sutcliffe, the Yorkshire Ripper case. Juries don't tend to let them use it anyway, because they generally don't accept the defence. But it won't include that sort of thing, because basically you still know it's wrong, you just can't control yourself, and that won't basically work under this. In cases where they did not know it was wrong, Windle's the sort of main case on this. He killed his wife. When the police turned up, he said, "I suppose they will hang me for this." So he clearly knew what he'd done was wrong, so therefore he couldn't use the defence of insanity. Johnson, he stabbed a man to death after he'd been provoked. And again, the evidence, there was dubious evidence from different psychologists saying whether he did understand. And in the end, they said that he did understand, so therefore he couldn't use the defence. And equally in Codir, he was convicted of murder, and he knew it was unlawful to kill. And in that case, he did make a point that it's not like people don't have to know that it's legally wrong to kill, they just have to know that it's morally wrong, like that it's wrong. And that's enough, that's sufficient to be under this test. It doesn't have to be they know it's actually a criminal offence. So just bear that in mind. If we move on to automatism now, so automatism is a full defence, so it's actually this one, in compared to insanity, this one actually results in a complete acquittal, which is why people tend to prefer this. So if we go back a minute and just look at these disease of the mind cases, Kemp, Sullivan, Hennessy, Burgess, all of them would have absolutely preferred to use automatism because it results in a full acquittal, whereas as we know, insanity gets the special verdict, not guilty by reason of insanity, and some of those options could be detention in a mental hospital, so it puts people off. The burden of proof is on the defendant, so the defendant has to prove this, and we'll talk about the issues with that shortly in the AO3. And really, automatism is made up of two key things, really. They have to have done an involuntary act, and that has to be caused by an external cause. And you see the difference there to insanity. This one's external cause. So we'll have a look at that. The involuntary act, it has to be involuntary, obviously. So you could be suffering from concussion, you could be under the administration of anaesthetic, it could be psychological trauma, it could be a blackout. And Bratty, case on Bratty v AG for Northern Ireland. In this case, he strangled a woman whilst giving her a lift. Lord Denning, I believe it was, or one of the, yeah, it is Lord Denning, sorry, described what automatism is, and he said it's an act done by the muscles without any control by the mind, such as a spasm, a reflex action, or a convulsion, or an act done by a person who is not conscious of what he's doing, as an act done while suffering from concussion or while sleepwalking. Although bear in mind, sleepwalking doesn't come under automatism, weirdly, even though he did mention it there. As we said, it does come under insanity. So it's sort of like reactions and things like that, things you don't actually intend to do. Classic I always describe as a reaction is if you put your hand on a hot stove or a hot cooker, not realising it's hot, you don't physically think, oh, that's hot, I'll take it off. Your body does it for you because of reactions and pain, neurons and all that sort of thing. You can probably, if you do biology, you probably know it more than me. So again, that's not something you did. So if you took your hand off, like if you did that with your hand and hit someone in the face by accident, you could claim that's perhaps automatism. Remember, the involuntary act must be done by caused by an external cause. It can't be internal. So this includes things like a blow to the head. Quite often you would say something like a flower pot fell on their heads or something silly like that. Could be attacked by a swarm of bees, for instance. Sneezing. We actually saw this in a case and allowed in RV Willie. He was on a motorway and he had a sneezing fit and he crashed into a car, and that caused a domino effect which hit, I think, 7 other cars. He was allowed, the magistrates allowed the defence of automatism, so he got away with it. He was acquitted because it was an involuntary act caused by an external cause would have been like dust or something like that making him sneeze. Hypnotism, possibly, I'm not going to go into that in depth, and possibly an effect of a drug like anaesthetic or insulin, which we will see, and we did see in Quick actually, where he injected insulin and then was able to use automatism. There is one key case on external cause which sort of illustrates it nicely. It's actually the swarm of bees analogy they use in Hill v Baxter. In Hill v Baxter, the facts actually were he failed to stop at a stop sign, but it's a famous case because the judge gave an analogy for an external cause, and an analogy is a made-up story to explain something. That's what it is. It's not actually what happened. And he said, imagine you're driving along and a swarm of bees coming through the window and you crash your car. Clearly, you didn't crash your car voluntarily. It was an involuntary action which caused an external cause with the bees coming in through the window. One of the big questions for the courts is, can stress be an external factor? They haven't particularly clarified this because there's two contrasting cases. RVT, she took part in a robbery and then claimed she didn't really remember anything, and she claimed she was suffering from PTSD from a rape a few days ago, and said she didn't really remember anything. And in this case, the court said exceptional stress can be an external factor that can cause automatism. So if that caused her to do an involuntary act, then she may be able to use it, although I don't believe the jury actually allowed that in that case. I think she was still convicted. Harvey Narber, as you can see, 14 years later, he stabbed a man, and again he's claimed he did it because he was suffering from PTSD due to childhood sexual abuse. And in this case, the court said no, stress cannot be seen as giving rise to automatism. They were really hard line on it. So you can see some conflicting cases there. Whether Narber perhaps is the precedent because it's the most recent case, we're not sure. But there is clearly some disagreement there in the courts as to whether stress can be an external factor or not. Useful for an essay point, unlikely to be brought up in a scenario, although if it was, you can essentially answer either way, basing your answer on RVT or RV Narber precedent, so it's up to you. What about if you have reduced or partial control? Well, the case of AG's reference, there are a number of cases on this, but I've chosen AG's reference. It says it has to be full lack of control. So in AG's reference, he was a lorry driver and he crashed into some parked cars on the hard shoulder, and I believe he killed some people actually, I think. And he was saying he was suffering from driving without awareness, which actually everybody suffers from when you're driving. If you actually have learned to drive, or when you do, quite often you'll drive and not remember how you got there, but you're driven safely probably, but you won't necessarily remember. It's called driving without awareness. And they said that's not enough because he was still in control of the vehicle, he was still keeping it straight, with the steering wheel, foot on the pedals, etc. They said it has to be complete lack of control to be an involuntary act. So he wasn't allowed to use automatism. Finally, what about self-induced automatism? Well, Bailey, he hit a man with an iron bar, and he's a diabetic. And basically, they said if the defendant has been reckless in getting into a state of automatism, self-induced automatism cannot be a defence. So bear that in mind. Obviously, look for that in a automatism part of the scenario. Don't need to mention self-induced for insanity at all. As I said, we've not talked about that because it's not relevant, so we can ignore that. But for automatism, you do need to consider self-induced, and obviously reference the case of Bailey, the precedent Bailey there for that. But bear in mind where the defendant does not know that his actions are likely to lead to a self-induced atomic state. So basically, he doesn't realise he's got himself into. You don't realise, or she doesn't realise they've got themselves into that state. Then actually you may be able to rely on defensive automatism because you've not been reckless. So in Hardy, he took a Valium, which is obviously supposed to calm you down. But actually had a adverse side effect and sort of hyped him up essentially, and he set fire to a wardrobe. And in that, he wasn't reckless because he didn't know there was a risk for that. He thought the Valium was going to calm him down. So he wasn't reckless, therefore it wasn't self-induced, they said. So therefore he could rely on automatism in that case. Looking at the A3, this is quite a nice essay. Whether you'll be asked specifically on insanity or specific automatism, we're not sure. So we're going to cover both here. If we start off with insanity, Obviously, it's a very old law. It was defined by McNaughton very long time ago. Obviously, like I said, that was extrajudicially as well. So you've got a criticism there, and the fact that it's defined by judges outside of a legal case, not even in the legal case, and not even by Parliament. There was little medical knowledge when the law was created. So when they talked about disease of the mind, the awareness of mental health was very minor. They were aware of it, but the treatment was non-existent almost compared to what we have nowadays in terms of drugs and therapy and all that sort of thing. So certainly we do probably need to update and reform the law to be in line with current medical knowledge and understanding. Even the name insanity is largely, not something we would use today. It's not PC to describe someone that's suffering from mental health as insane. So certainly that needs looking at. They have reformed the sentencing options, which is a big positive. So as I said, in 2004, they changed it because it used to be compulsory detention in a mental hospital. They have now changed that to allow for supervision orders or perhaps even an absolute discharge. So if people are like diabetics or epileptics and end up being prosecuted under this and only being able to use insanity as the defence, whilst they will be found not guilty by reason of insanity and have to use insanity, which could be quite insulting considering they're not insane clearly, they could get an absolute discharge from that, which means they are essentially still getting acquitted, essentially. Definition of disease of the mind, obviously it is a legal definition, not a medical definition. Again, medical technology has changed significantly. Medical knowledge, understanding, not technology. People that we would normally class as insane won't necessarily come under it. So Sutcliffe, Byrne, for instance, won't necessarily come under this definition. But people who we wouldn't want coming under it do. So people like Kemp, Burgess, Sullivan, who suffered from epilepsy. Kemp was the arteriosclerosis, hardening of the arteries to the brain. Those people clearly aren't insane. They have physical conditions which led to it, which is clearly automatism rather than insanity. Yet the law isn't, because it says it's an internal cause, they're narrowing down this to insanity really, which then puts people off. People plead guilty to that, which is then a miscarriage of justice really, because they're pleading guilty to an offence that actually they really shouldn't be liable for because they would have a defence. So you've got some issues there. There is obviously a huge overlap with with automatism. This internal-external divide it's all about basically allowing supervision. So if the idea is if it's an internal cause, then it's likely to happen again. Therefore, the courts, to protect the public, need to do something with you, whether that's give you a supervision order or put you in a mental hospital or do something with you. Whereas if it's external, it's very, if a bang to the head or dust making you sneeze or something like that, then it's very unlikely to happen again. The chances are. So actually, they can just give you a full acquittal and go, it's just an accident. Whereas if it's internal, you could have a reoccurring situation of it happening again and again and again, and therefore they do need to do something about that, which is the justification for the internal-external divide. But as you can see, it doesn't really work with cases like Kemp, Sullivan, etc. There are issues around knowing the act was wrong, etc. So basically, an Australian case differed from Windle and Johnson, and actually in Johnson, they actually saw some merit in this case. The judges actually said, well, actually, we could look at this Australian case, but because they're due under normal English precedents to follow Windle, they couldn't actually go down that tangent and explore the Australian case because that's obviously persuasive precedent only. So clearly the judges are looking at that and looking at whether we should depart from the sort of strict interpretation there as to what that means. So, and perhaps move towards the Australian method there. But we certainly won't be anytime soon, I would imagine. Number 5, obviously there's a huge social stigma. And like I said, many defendants claim guilty instead, which is hugely unjust. Like I said, that's miscarriage of justice. If you look at Sullivan, for instance, an example there. Now the reform suggestion from the Butler Committee, quite a long time ago, in the 1970s, I believe, was that it should be changed to not guilty by reason of mental disorder. Obviously that would be a hugely positive change. That's much better language than insanity. People may feel more comfortable using that, although it still obviously has stigma. But obviously it hasn't been passed, it was rejected, so it hasn't been brought into force. Otherwise that's what we'd be looking at. 6, it's barely ever used. So the general figure is about 8 times a year. That may vary year to year. So it's virtually never used as a defence, which you might think, well, why are we learning it then? But of course it is still valid. Should it simply be removed then? You know, you've got crossover with diminished responsibility, or remember that is only for murder though. You can only use diminished responsibility for murder as a partial defence. You know, in the 1990s, you had about 5 people using insanity a year, whereas you had 50 people using diminished responsibility a year. Although interestingly, claims for both have diminished or reduced over the last sort of 10, 20 years altogether. In both categories. So we still obviously have more people, like I said, we still have more people using diminished responsibility, far more than insanity. And that again is only for murder. You've also got a lot of powers under the Mental Health Act now, which allows for dealing with issues with people with extreme mental health problems much more in a more humane and safer way than perhaps through the legal justice system. So that's something to consider as well. Automatism and insanity, they're all defined under common law. So obviously you've got all the normal issues around judicial lawmaking, separation of powers. Remember Montesquieu came up with separation of powers idea and parliamentary supremacy, so you can go into that in some detail. Number 8, you can only use automatism where there's an external cause. This is confusing, particularly if you compare cases like Hennessy and Quick, both suffering from diabetes. How can one be insanity and one be automatism? It just doesn't really make any sense. But generally, the courts have reduced the number of people escaping all liability, because this is often seen negatively by the public. And the way they've done this is by reducing the scope of the defence of automatism. They've made it quite hard to use because they don't want people escaping all liability, and the court simply saying, well, it's not their fault, you know, because then obviously there's victims involved who aren't generally happy with that. One good example where they've narrowed automatism is sleepwalking. So we class that as insanity in England and Wales. Whereas Commonwealth jurisdictions such as Australia and Canada class it as automatism. So that's significantly different and something we really probably should move towards. 9 has to be a full loss of control. So it is actually quite a hard test to prove. That stops people claiming partial loss of control you know, too easily and things like that, and saying, well, I should be automatism. That links to the point above about stopping people from escaping all liability because it's unpopular with the public. Plus, self-induced automatism is not allowed. So would it be too wide if they did? Probably. It's been suggested that in cases such as Quick and Bailey, the law could apply the rule only to cases involving drugs and alcohol. As it's widely known, they can have a adverse effect on people. So they've sort of said, well, self-induced should only apply to drugs and alcohol, which is probably, again, a sensible solution. We can see they've done that in lots of areas of law where they've said, well, it can't be an intoxicating mistake in self-defence and things like that. So you can see that there. Number 10, finally, the proof is on the defendant, which seems a bit odd. Obviously, that goes against Article 6 European Court of Human Rights, right to a fair trial and things like that. Should it really be left to the jury to decide? You know, they're not medical experts. And also, as we know, revulsion from juries can lead them to ignoring mental illnesses and ignoring defences and saying, well, the person's guilty anyway, as we saw in Sutcliffe, the Yorkshire Ripper case. So you can take that into account. When you're looking at a scenario on this, finally, it's really important that you answer the question specifically. So if it's asking just for insanity, then just apply insanity. If it's asking for just automatism, then just apply automatism. Normally, you would I'll be asked one of both. So it doesn't matter which order you do them in, but make sure you cover both of them. And make sure you just methodically apply the test. So with insanity, make sure you cover, is there a defect of reason first? Is it due to a disease in the mind? Did that mean they didn't know the nature and quality of that, or that it was wrong? Make sure you're saying why to each of those and linking it into any cases if you can. And obviously make sure, if you are saying they can use insanity, make sure you say at the end that therefore they would get the special verdict, not guilty by reason of insanity, and even go on to suggest perhaps what sentencing option they might get, and that's really a strong answer there. And with automatism, make sure you apply the 2 parts of the test there. So is there an involuntary act and is it due to an external cause? And then just make sure you consider anything like full loss of control, stress, or quite often what comes up is the self-induced part. So make sure you look at that. Hope you found that video useful, and there'll be one more coming up on duress necessity, and then you'll have every topic under criminal law for you to revise. Thank you very much.